This is Gary Davidson, and I head the practice group here at Castle Law for real estate. One of the things I want to talk about is what are the parties' obligations for performance of the contract? When you post earnest money, many times people think that that is the one and sole obligation if a buyer or seller defaults. So, in other words, if the buyer fails to comply with the terms of the contract and they've only posted $500 earnest money, they could cancel on the day before the closing after they've been under contract for 60 days, and they would simply give the $500 to the seller. That same thing with the seller. The seller similarly thinks, well, I can just give the earnest money back. But you need to understand that in most real estate contracts, the contract provides that if either party breaches and the other party is found to be in breach, that you can actually compel the buyer to buy the property. And conversely, you could compel the seller to sell the property. Furthermore, if the party who files suit is found to have done so properly, that party will be entitled to all of their attorney fees. So, again, when you're reading these contracts and when you're signing them, understand they're written in plain English. You can read them left to right, up and down. No one forced, threatened, or coerced you to sign that contract. And you cannot claim that you didn't understand or that you don't or that you didn't read the contract. So know what you're signing, review it, and if you do decide that you need to cancel, it's very important to talk to us here at Castle Law so we can minimize your risk and maximize your return in the event that we have to get out of a contract.